Florida Department of State Division Corporations, Florida Not-for-Profit Corporations Act. 617-2001 corporate, which may have been incorporated with the year under the incorporation certain medical services corporation. Corporation may or the incorporated under this act for any one or more of the lawful purpose of the pre-announced profit right. However, the corporation non-profit which may be incorporated under the aim of the law of the state governing particular type of the corporation may be incorporated under this act. The corporation non-profit organized prior to December 1st, 1987, pursuant to the provisions of Chapter 85-56 of the law of the Florida of the provision of Statute 2 with the Chapters 87-296. Laws of Florida may be conducted in practice medicine and conduct programs in medical education carrying on the major medical research efforts. 617-2002, the corporation of the nonprofit reorganized pursuant to Statute 2, Chapter 87-296 requirements of the corporation for the nonprofit organized pursuant to the provisions of Statute 2 of the Chapter 87-296 laws of Florida must meet the following requirements. At least 25% of the physician must have a full-time contract provision of medical services with the corporation be conducted with certified and special and appropriate American Specialist Board with the Council for the Medical Education of the American Medical Association with the clinical privileges of one more hospitals in the state. Hospital owned with the corporation organized pursuant to Statute 2 with the Chapter 87-296 law of Florida must provide with medical charity care. 617-2003, proceeding with the revoke article of incorporation for the charter preventing its chief. If any member of the citizen complains with the Department of Legal Affairs for the aim of the corporation organized after the act of the organized with being used for the effort to evade the aim of the laws against for the crime for the purpose inconsistent with those stated with the articles of incorporation of the charter that as the officer or director for the corporation has participated in the sale of the transaction is affected with the conflict with the interest for the which he or she derived with improper benefits, personal benefits, either directly or indirectly, with the shall submit the prima facie as evidence to sustain such a charge, and together with sufficient money to cover the court cost expense of the department shall institute the due of the course and prosecute the final judgment of such a legal or equitable the proceedings as may be considered advisable either provoke the articles of incorporation of the charter to prevent the improper use of the recover the behalf of the corporation or its own beneficiary of the profits improperly received by the corporation and its officers or directors. 617-2004, existing church of the religious society property of the property of both real and personal belonging to the whole and trust for the church for any religious society belonging to any religious denomination in the state has the or shall be existing shall be vested and become of the property of the denomination of which such church of the religious society is a member. However, the section shall not affect the title of the property that is not held in any of the denominational association or organization of the state. That is section that shall not affect the reversionary interest of any of the person and property any valid lien of the thereon. Or 617-2005, existing church of the religious society, the dissolution nature of the religious society, state whether they cease or fail to maintain the religious worship, the services used the proper religious worship, the services according to the tenets of the usage and the custom of the church, the denomination for which the members in stay with the space for the 2 consecutive years who the membership the diminished in the numbers and final strength of the render of the impossible for the such of the church and society to maintain religious worship, the service to protect the property with exposure of the waste and depredation for a period of 2 years shall be the existence upon the facts of being extinguished with the satisfaction of the circuit court in the county or in the county in order that such courts may be made dissolving the church of the religious society with the property decided for the church of the society of the property which may be held within trust with the much of the such of the church and society may be the court with the transferred in the title of the precision thereof vested in the domination with which such church of the society most member the copy of the degree of dissolution shall be filed within the Department of State. 617-2006, Incorporation Labor Unions Body. The group of the combination of the group of the workers and wage earners before the name of the labor, the organized labor, the Federal Labor Federation of Labor, the Brotherhood of Labor, the Union, Labor Committee, the Trade Unions, the Trade Unions, Union Labor Council Building, Trade Council of the Building, Trade Union, Allied Trade Union, Central Labor Body, Central Labor Body Union, Federal State Council, Local Union, State Union, National Union, International Union, District Labor Council, District Labor Union, American Federation of Labor, Federal Federation, Florida Federation of Labor, or in components parts, significant parts of the word surface, whether the same is being used in juxtaposition and whether the interest space may incorporate under this act. In addition, with the requirements of statute Statute 617.02011 or 617.02002, Article of the Incorporation of Labor of the Human Body shall be for the necessity of the incorporation shall inscribe not less than 5 persons shall be acknowledged with all the subscribers will also become the subscribed with an oath to be endorsed by the Articles of Incorporation that is intent with the good faith to carry out the purpose of the objectives set forth in the Articles of Incorporation. The Articles of Incorporation should be filled with the office of the clerk of the court of the county with the labor of the union body with the organized with the approval of the judge with the circuit of the court shall be obtained. Subscriber in the article of the incorporation shall be given the notice of the intention to obtain the approval thereof of the circuit judge with the notice of the state with the name of the judge. The date and the articles of the incorporation shall be presented with the great nature for the necessity of the articles of incorporation. Notice shall be published in the newspaper general circulation in the county which the labor union body with the organized at least one or posted. The courthouse door in counties have no newspapers at least 10 days prior to the date of the articles of incorporation will be presented with the judge. When presented with the judge, article for the incorporation shall be accompanied with a petition signed and sworn by the subscriber starting with the full aim and purpose of such organization for the necessity thereof. Upon filing articles of incorporation, the petition given in such note of the circuit judge to whom such the petition of the address shall be upon the date stated with such note of the testimony inquiring the admission, purpose of such organization, and necessity thereof. Upon such hearing, the circuit judge there shall be satisfied allegations set forth in the petition. Articles of incorporation have been substained, and shall find the organization will not harmful to the community in which the purpose of the or to operate of the state with that is intent with the good faith to carry out the purpose of the objective set forth in the articles of incorporation, therefore necessity thereof the judge will approve the articles of incorporation endorsing her approval thereof upon the filing of the articles of incorporation endorsement thereof upon the Department of the State and the paying the filing fee specified in statute 617.022. The subscriber there associating success for this shall be a corporation that getting given. Any person intervening with the file answer the petition stating that his or her reason with if any with heard thereon, the circuit judge shall not approve of the articles of incorporation. The existing amendment of the articles of incorporation dissolution of any of such corporations shall be in accordance with the act. 617-2007. Sponge packing and the marketing corporation. The person engaged with the business selling and selling packaging, marketing, commercial sponges may incorporate under the act of the facilitating, orderly comparative buying, selling, packaging, marketing the commercial sponges. For such action must not come beneath the restraint, trade, or illegal monopoly, or attempt to lessen the competition for fixed properties, or arbitrarily any market member contract or agreement with the corporation of the membership of the exercise of any of the power granted with the act if not illegal and in restraint of the trade. Alright, 617-2101. Corporation authorized act as a trustee and corporation organized under the act that may act with the trustee property whenever the corporation has either beneficial contingent remainder interest in such property. The corporation may accept the whole legal title of the property, the beneficial interest in which they own by any other illuminatory institution, non-profit organizational fraternal, beneficial, charitable, and religious society of that association. 617-2102. The fines and penalties against the member of the corporation may be authorized in by law of the levy the fines otherwise penalize the members of the corporation. No fine penalty shall be levied until the corporation has provided notice that they are the member of the concern that has afforded the member the opportunity to hear of the matter, but the foregoing notice the year shall be not required, but as levy the fee the non-payment of dues. Alright, 617-2104, Florida Uniform Prudent Management Institutional Funding Act. Short title, this section may be cited as the Florida Uniform Prudent Management of the Institutional Fund Act. B. Definition for the purpose of this section, charitable purpose of the means of the relief of the poverty, the evidence for the education, religion, the promotion of the health, and promotion of the governmental purpose, and the purpose of the achievement of which the beneficial for the community. Endowment fund with the means of the institutional fund, therefore, under the term of the gift and instrument, but not wholly exampled by the institution of the current base for the term, and it does not include assets so that institution to designate as an endowment fund of its own use. Or a gift and instrument with the given means of the record of the government include with the institution solicitation under which the property with the grant of the transferred and held by an institution of the institutional fund. The institution means a person organized, operated with exclusion for the charitable purposes other than individual or a trust subject to the statute 518.11. Government or governmental subdivision agents for the instrumental to the extent of the whole of the funds of the exclusively with a charitable purpose. The trust has been both charitable and non-charitable interests after all the non-charitable interests have been terminated. If the trust is not subject to Statute 51811, the institutional fund, meaning the fund that had been an institutional exclusive with a charitable purpose, the term does not include the program-related assets. A fund held with the institution trustee and it's not an institution. 3. A fund with the beneficiary that not an institution but it has an interest with it other than interest with the collateral right with the violation failure of the purpose of the fund. Funded management administrator of the state of the board of administration pursuant to its constitutional status or for what a person means with an individual corporation business with the trust a state with a trust and partnership limited liability company association joint venture public corporation with the government and governmental subdivision agent for the instrumental any with other legal common commercial entity program related assets the means of the assets of the held by the institute primarily accomplish charitable purpose of the institution not primarily invested record or mean the information been inscribed with an intangible medium stored in the electronically other medium in a relatively perceivable standard form. 3. Standard conduct in managing and investing in institutional funds. Subject to the intent of the donor expressed by the gifts of the institution and managing of the investment of the institutional fund should consider the charitable purpose of the institution, purpose of the institutional fund. In addition to complying with the duty of the loyalty imposed with the law of the other than those which such a person responsible for the managing investment of the institutional fund shall manage for the investment fund in the good faith in which the care of ordinarily prudent person like person position will exercise under similar circumstances. C. Managing investment institutional fund of the institution may incur with the only cost of the appropriate the reasonable relation for the asset purpose of the institution skills available to the institution should make a reasonable effort to verify the facts relevant to the management investment of the fund. Institution may pool 2 or more investment funds for the purpose of the management and investment. Except of the otherwise provided with the gift or instrument following the rules applied. In managing the investment of the investment fund following the factors relevant to the must be considered general economic conditions, the purpose of the possible effect of the inflation, the deflation, the expected tax consequences in an event of the investment decision strategy, the parole of each of the investment, core for the act section played with the overall investment portfolio of the fund, expected total return of the income, the appreciation of investment of the resources of the institution, the need of the institution fund to make the distribution, preserve the capital. And 8. An asset for special relationship with special value and any of the charitable purpose of this institution. Alright, 2. Management investment decisions about the individual asset must be made not in isolation, rather than in context of the institutional fund portfolio investment as a whole part of the overall investment strategy, having the risk of return objective the responsible student of the fund and the institution. 3. The example that otherwise provided by the law other than in the section, the institution may invest in any kind of the property type of the investment consistent with this section. 4. An institution shall diversify investment with the institutional funds unless the institution responsibly prudently determines under the section purpose of the fund are better to serve the diversification. Without reasonable time of the receipt of the property, the institution will make will carry out the decision concerning the retention of the disposition of property rebalances of the portfolio in order to bring the investment institutional fund in compliance with the appropriate for the term and the distribution requirements of the institution as necessary to meet the other circumstances for the institution and the requirements of this section. 6. A person with special skills or expertise is selected in reliance upon the person representation with the person that has special skills, expertise, the duty to use those skills or that expertise in the managing investment institutional funds. Appropriation for the expenditure for the accumulation for the endowment of the fund, the rules of the construction, subject to the intent of the donor for the express for the gifts of the instrument of the institution may be the appropriate expenditure for the accumulated so much of the endowment fund of this institution will determine the prudent for the use of the benefits and purpose of the variation which the endowment fund is established unless stated otherwise. The gift of the instrument is an assess of the endowment of the fund, but the donor restricted as assets appropriated for the expenditure for the institution, making the determination appropriate the accumulated the institution shall act with good faith on which the care of the ordinarily prudent person like the position would exercise similar circumstances shall consider the event relevant full following factors. 1. The duration preservation endowment fund with the purpose of the institution of the endowment fund, the general economic conditions. 4. The purpose of the possible effect of the inflation, deflation. 5. The expected total return from income and the appreciation of investment. 6. Other resources of the institution. Then 7. The investment policy of the institution. B. The limited authority appreciated with the expenditure accumulated under paragraph A with the gift instrument must specifically state the limitations. C. Terms of the gift instrument designated with the gift is endowment, the direction of the authorization of the gift instrument, with the use of the income, interest, dividends, rent, issue of the profits, or to preserve principal intact, with the words of the similar import. 1. Create the endowment fund with a permanent duration unless on other language of the gift instrument limits the duration and the purpose of the fund. Do not otherwise limit the authority with the appropriate expenditure for the accumulate under the paragraph A delegation of the management and investment of the functions. Alright, A. Subject to the specific limitations set forth in the gift instrument allowed other than section of the instruments delegated with the external agent of the management and the investment of the institutional fund to the extent with the institutional predominantly delegated under the circumstance the institution shall act with the good faith and with the care of the with ordinary prudent person in like with the position would exist at the similar circumstances select agent establish the scope of the term delegation consistent with the purpose of the institutional fund periodically reviewing agent section order the monitoring the special agent's performance of the compliance with the scope and the terms of the delegation. B. Informing the delegated function agent with the owner of the duty of the institution to exercise reasonable care with the complying with the scope and the terms of the delegation. C. Institution comply with the paragraph A and is not liable to decision action for the agent with which the function was delegated. D. By accepting delegation of the management and investment function of the institution subject to the laws of the state and agent with a submit the jurisdiction of the courts of the state, all proceeding arising related to the delegation performance of delegated function. Alright, E. An institution delegated management investment function with the committee of the officers employees are authorized law other than section 6. Release and modification restriction on management investment or purpose. And if the donor considers the record institution may release and modify into a whole part or in part restriction contained with the gift instrument on the management investment purpose of the institutional fund. The release of the modification may not allow the fund to be used for profit purpose other than charitable purpose of the institution consistent with the donor record with it cannot be obtained with the reason with the donor's death, disability, invalidity, impossibility, identification, and governing board may modify the restriction contained in the gifted instrument regarding with the management investment of the use of the initial institutional fund with the defined with the total of $100,000 left. The restriction becomes impractical, wasteful, impaired with the management investment and use of the fund with because of the circumstances not anticipated with the donor modification of the restriction will be further purpose fund. Institution determine the restriction of it contained with the gifted instrument with the management investment purpose of the institutional fund unlawful, impractical, impossible to achieve the wasteful institution after providing with the written notice for the Attorney General may release the modifying the restriction and with the whole part of one institutional fund subject to the restriction in total value of at least $100,000, not more than $250,000. More than 20 years have elapsed since the fund was established. The institution used the property manner with the consistent charitable purpose expressed in the gift instrument. The Circuit Court of the Circuit within the institution located an application for the institution modified the restriction contained with the gift instrument regarding with the management and investment institutional fund with the restriction become impractical to waive if it impairs the management investment of the fund and become with the circumstance not anticipated with the donor modification restriction with the further purpose of the fund. The institution will notify the Attorney General of the application to extend the practical modification must be made with the accordance with the donor probable intention of the practical charitable the purpose of the restriction contained with the gift instrument you with the institution fund to become the unlawful practical and purpose to achieve the wasteful the circuit the court circuit which is institution located upon the application for the institution may modify the purpose of the fund and restriction the use of the fund in the manner consistent with the charitable purpose expressed in the government gift instrument. The institution will notify the Attorney General of the application. 7. Reviewing compliance with the compliance with the protection with the determined in light of the facts and circumstances exist at the time of the decision made or action with the time taken with not in by hindsight. Application to existing institutional funds. The section applied with the institutional funds existing with the established and effective date of the section applied to institutional funds existing with the effective date of the section with the section governing the only decision made with the reaction taken with the offer after the date. 9. In relation to the electronic signature of the Global National Commercial Act, this section modified the limited supersede the federal election signature of the Global National Commercial Act of the Title 15 U.S. Standard Code Statute 7001 extent sequence, but does not modify the limit of the supersede of the Statute 101C over the Act of Title 15 U.S. Standard Code 7001C, the authorized electronic delivery of any of the notices described in Statute 103B of the Act of Title 15 U.S. Standard Code 703B. Alright, application of existing institutional funds. The section applied for the institutional funds existing established after the effective date of the section applied for the institutional funds existing effective the date of the section, with the section go for the only decision made by the actions taken after the date of relation to electronic signature for the Global and National Commerce Act. Section modified, we read that uniformity of the application and construction. They have been applying with the Construction Uniformity Act, so the consideration was given the need to promote uniformity of the law with respect to the subject matter and among the states that enact it. 617-2105, corporation issued deed to read real property.